All right, hello, welcome again, Employment Law Show. John Scholes here. So good to see you this week. Beside me, Lior Samfiru, founding partner, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed employment law firm in the land. That you can do your own research. You'll find out what I just told you to be true. Some contact information before we dig into the show: 1-855-821-5900. Anytime you want to get a hold of Lior and his team, that's the number to do it. Help at employmentlawyer.ca, and I'm going to be feeding a bunch of these to you throughout the half hour, but I'll give you a website off the top you can use anytime. Designed just for you to get more employment law knowledge. Free, anonymous, pocketemploymentlawyer.ca. And rolled into that is the trusty, as Lior calls it, trusty severance pay calculator. It has literally been used by hundreds of thousands of people over the last several years to figure out exactly what their severance should be, because when you get a severance offer, it is wrong. We'll tell you that right off the top. Again, pocketemploymentlawyer.ca. Lots of emails to get through. We're going to get some phone calls from our radio show, which has been happening for about a decade now. We pull the good ones, drop them into this show, and we talk about them. As well, the topic for today, Lior, 5 questions to consider before resigning from your job. Huge key information. 5 points coming from that in just a bit. But Lior, my brother, we always start with the week that was. How are you, fella?
Hey, John, good to be back. Good to be talking about employment law. Good to be trying to help as many people as possible. So if you're tuning in for the first time, we talk about your workplace rights. We tell you what you need to know. You're facing a workplace problem, or if you're dealing with a conflict in the workplace. Things are not always going to be smooth sailing. Things are not always going to be good. So if you are dealing with a workplace conflict, maybe an ultimatum, maybe being mistreated, maybe your job is in jeopardy or you lost your job. We're going to tell you what you need to know right now about your legal rights, what the law says you should do, what the law says you should have. So this is the opportunity to learn about those things that you've always wondered. Even if right now things are great, things may not always be great. So to learn now, to understand your rights is a good thing to do. And of course, if you want to reach out to me privately so we can have a discussion specifically about your situation, we'll give you that contact information throughout the show so that we can connect that way. But to get started, as John said, I always like to start with the week that was, a situation that came across my desk over the past few days. So, John, this is a situation that's come across my desk hundreds of times over the past few months. And here's what it looks like. It's specifically one that I spoke with the gentleman this week. He was told 2 months ago that he has 2 months to get his COVID vaccine, to be fully vaccinated, and that if within 2 months he does not do that, if he cannot show that he's fully vaccinated within 2 months, his employment will be terminated for cause. So fast forward 2 months later, he's decided for his own reasons not to be vaccinated. His employer said, well, we told you about that deadline, so we're going to go ahead and terminate you for cause. So this employee wanted to obviously understand what his rights were. He contacted me. So here's something to consider. First of all, what is cause? Cause is a situation where the employee did something so bad that it's impossible to continue employing them. So is not getting the vaccine in this situation cause? Well, let's think about that. His employer told him 2 months ago that you can work for 2 months. Everything will be fine. Don't worry. Continue working for 2 months. And in 2 months' time, at that point, we will have cause if you don't get vaccinated. Well, wait a second. If he can continue working for 2 months, if it's fine that he can continue working for 2 months, how can it be cause? How can he have done something so bad, but for 2 months it doesn't matter? Well, it's so bad, but not for the first 2 months. You can continue working, and then it's going to be cause. It's not cause. And by giving him 2 months to do that, the employers essentially confirm that. So in most situations, unless, again, there's a government mandate, if you lose your job or if you're suspended because you choose not to be vaccinated, it's not cause. There's very good reasons, of course, to be vaccinated, and I think people should. But for those that don't and lose their job, they're going to be owed severance. It's going to be considered a without cause termination. There's many reasons for that. And I don't think, John, employers quite realize the liability that they have.
You know, it's interesting. We've talked about this, and we will continue to talk about this particular point, Lior, as the weeks and months go on, because it doesn't look like it's going to slow down for some time. But, you know, you slip that if it's a government mandate in there. And I know we've hammered this point home before on past shows, but I just want to keep putting it out there. Is there a difference between a government mandate as it pertains to employees versus working for the federal government as far as being let go and not getting paid severance?
So let's a government mandate is a situation where your employer essentially has no choice. If the government says you're not allowed to have an employee working unless they've been vaccinated, then the employer has no choice, has no say. And in that situation, if the employee is not vaccinated, the employer can let the employee go without any compensation. Now, that applies to certain employees that are federally regulated or provincially regulated if the government says you have to. Now, the fact that you work for a federally regulated employer does not mean that there's a mandate that applies to you. For most federally regulated employees, there's no mandate. People that work for banks, people that work in trucking or telecommunications, there's no government mandate. So ultimately, if you lose your job, you're owed compensation. Certain people that work for core departments of the federal government, there's a mandate that applies to you. But again, for most people, right now, as we speak, there's no mandate.
Again, 1-855-821-5900. Anything seems confusing, call Lior and his team anytime. Have a more relaxed, conversational, lengthy chat, 1-855-821-5900, help@employmentlawyer.ca. Now, if you just go to employmentlawyer.ca, the website, you'll get a media tab there, a drop-down menu across the top, I believe, still. And you'll be able to search out where you can catch our long-running radio show. It's about an hour long. It's been going across the country for about a decade. We got loyal listeners. They phone all the time with questions. They ask good questions. We answer them on the radio, but they're so good, Lior, we'd like to pluck a few of them out and drop them into this show. We're going to get to our first phone call from the radio show here now.
I've been working at a brokerage for 14 years. I'm 69 years old, and they just sold to another business. I'm worried when they come to us this month with the new terms or whatever they're going to bring us, the new HR people, can they let me go because of my age?
Oh.
That is a question, John, I get often, and that this concept of age discrimination is real. Employees, I've seen it time and time again, have been let go illegally, of course, because of their age. So let's be very clear. You cannot be let go because of your age. By the way, we don't have any more such thing as mandatory retirement. That's gone, been gone for many years now. So you are allowed and able to work as long as you want. And age should not even be a factor in deciding whether you keep your job or you lose your job. Shouldn't be a factor. Now, I know that a lot of employees are going to say, well, I was let go because of that. If you have been, that's a human rights violation. You're entitled to damages. You're entitled to compensation. It's not a legal thing. Can't do that. Now, for this particular lady, she can't be let go because of her age. Like I said, human rights damages. And beyond that, beyond just the human rights damages, of course, she's going to be owed severance. So, John, you mentioned at the top of the show our handy-dandy severance calculator, which is available at pocketemploymentlawyer.ca. So let's take our information and just for fun, let's plug it in to pocketemploymentlawyer.ca and let's see what she'd be getting just in terms of severance. So this lady is 69 years old, a brokerage coordinator. She told us she's been there for 14 years. You can see at the bottom, she's easily going to be owed 16 months pay. And John, that's conservative. That could be more. It can be 18 to 20 even. So that's how much severance she's owed. And by the way, what I just did here, you could do yourself. Just go to pocketemploymentlawyer.ca ever if you lost your job or are worried about losing your job.
Now, if it does come down, she does get let go. Looking at severance, she said the new owner fires her. Is it the severance the responsibility of the previous owner or the new owner, the buyer?
So if she actually starts working for the new owner and then the new owner lets her go, then that new owner has to pay her severance. If she never works for them, then it's only the old company that has to pay her severance.
Is there any telltale signs for someone in this situation, Lior, that, you know, maybe it was my age. How do I tell? Is there any way, surefire way to tell that it was your age? They're not going to tell you it's because you're 69. Is there any way to tell that it may have been your age? I mean, if you're singled out, the only person that got let go or something like that?
So by the way, John, I have seen employers not very smartly telling employees, yeah, we're letting you go because of your age, or we're letting you go because we're bringing younger blood, new blood. No, it's silly, ridiculous, of course, illegal. But yes, there are ways. So first of all, if you are the only one let go and everyone else is not, and they're younger, that may be the reason. If it's a situation where you've already been given advice, are you going to retire? Should you retire? When do you want to retire? And then you are let go, then you can probably safely assume that age formed a factor in that. So, if it looks like a duck and quacks like a duck, it's probably a duck. And I think that applies here as well.
We mentioned it before, terminationquestions.com, or if we haven't, I'm going to right now, terminationquestions.com, exactly that, another website for you to use. You can go there, ask your questions to Lior and his crew. They will be answered in full, and you'll get some satisfaction. We bring them on the show as well, Lior, as you know, every week. First one this week is from Sarah. She says, I was fired just days after emailing my boss to tell him that I was pregnant and would be taking an 18-month maternity leave. Nobody else was laid off, and the company isn't cutting costs. This does not look good.
Yeah, well, John, this is exactly actually what we've been talking about. She's been let go. She's not, of course, being told that she's being let go because she's pregnant or taking a leave. But come on, I mean, who is ever going to believe that there's any other reason but that? She tells them she's being let go, and all of a sudden, or that she tells them that she's taking maternity leave. All of a sudden, she's let go. She's the only one. Clearly, that's the reason. So let's remind people, even though we shouldn't have to, such a basic thing. You cannot be let go because you're pregnant, about to become a parent, taking parental leave, coming back from a parental leave. You cannot be let go, punished, job change, reduce of pay. None of that can happen. You have to be allowed to take your leave, which again can be as much as 18 months, and be brought back to the same pay. It's a violation of several statutes. If that doesn't happen, and in some cases like this one, John, it's obvious really what's going on here.
Sarah's taken 18 months. It's a long time. It's some of the awesome laws we have in this country allowing prospective mothers to do that. During that 18 months, though, companies still got to function. So they get someone in to do her job, maybe bring someone in-house, maybe they bring someone from the outside. This person is an absolute rock star. What happens in 18 months when Sarah wants her job back, but they like the new person?
Well, you're absolutely right that a company should and has to continue running its business, and they can do whatever they need to in that 18-month or however long Sarah's away. But when she's ready to come back to work, regardless of how much they like her replacement, they still have to take Sarah back to her old job, her old pay, her old responsibilities. Now, maybe there's still a way to find work for the new person, but it can't come at Sarah's expense. She has a right to be reinstated to her old job, no exceptions.
Coming up here after we take a short break, 5 things you need to know before you resign. This is key information, so please stick around with us. In the meantime, 1-855-821-5900, help at employmentlawyer.ca. And we'll continue. Lots more Employment Law Show is on the way.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Employment Law Show. John Scholes and Lior Samfiru. Again, co-founding partners, Samfiru, Tumarkin, LLP. You want to reach out anytime, get the compensation you deserve, you are owed. It is not a lottery ticket, your severance. It's not a windfall. You're owed that money, and chances are your employer is going to offer you a lot less, pennies on the dollar to what you should be getting. So reach out to Lior and his team anytime, 1-855-821-5900. But we always have an important topic every week, Lior. People need to know this stuff, and beyond reaching out to you for the phone, with an email, or going to pocketemploymentlawyer.ca, we talk about it here. And this week it is this: 5 questions to consider before resigning from your job. Diving right into number 1. Do you get severance pay or EI if you voluntarily resign from your job?
So, by the way, John, this is a question that I get asked very often. I actually, over the past couple of days, I got an email from a lady who had worked for the same employer for going on 30 years. She decided she's going to leave.
Wow.
And she asked me, what am I owed after 30 years? Well, here's the thing. If you ultimately choose to leave voluntarily from your job, regardless of whether you're retiring or going to work somewhere else, you're not owed compensation. When the decision is made by you for your own good reasons, even if you've put in the time with the company, even if you've been a great employee and a valued employee, you're not going to be owed compensation. So it's important to remember, before you resign, are you willing to walk away from potential severance? If the company lets you go, of course you are owed severance. It's not something that you get if you resign voluntarily. Now, there are situations, which we'll talk about in a minute, where despite resigning, you may still be owed severance. But if it's just a run-of-the-mill situation where you've decided, you know what, I've had a good career, I'm going to say goodbye and move on, in that case, John, no severance, no compensation is owed to the employee.
Okay, now number two may be part of what you're just talking about there. Number two is, can an employer tell or ask an employee to resign?
So a resignation, by its very definition, is something that an employee can only do. It's something that an employee must do voluntarily and must do unilaterally. It's not, they don't do that because someone told them. The moment someone tells you to do something, it's not voluntary. So if you've been told, well, you have to resign, we're expecting a resignation letter by 5 o'clock, well, even in that situation, if you do resign, it's not a resignation, it's a termination. The company is essentially saying to you, you don't have a job here, so give us your letter of resignation. Well, it's the company making the decision, not you. So the law is going to view that as a termination. And in that case, yes, you're going to be owed severance because it's a termination. So if you don't want to resign, say so. Don't resign. And if you do resign, make sure that it's clear that you're not doing that of your own volition.
It's interesting because that second one kind of leads into number three, and someone says, you get the old, you better resign or else we're going to let you go. So this employee panics, thinking maybe I'm better off resigning because it looks bad. It's an ugly label to show that I was let go, fired from my job. There might be this vault of my work history. People are going to find out I was fired, so I'm just going to resign, do what they say. Is that a smart thing to do?
I've been asked or been told that by employees many times. Well, I knew they were going to let me go, so I decided to preempt that by resigning because I thought that was better for me. It's not better. It's worse. There is absolutely no reason whatsoever why you would choose to resign rather than be let go or be terminated. There isn't. There isn't, by the way, a database where there's a massive spreadsheet that shows why someone is no longer working for a company. And the reality is that if you are let go, then it's just much easier to get you severance. Whereas if you believe the company is going to let you go, so you choose to resign and to kind of preempt and beat that, then you potentially are giving up your severance. Don't do that. Don't resign unless it's purely voluntary, unless it's done without pressure, without intimidation. Otherwise, it is better to be let go than to resign.
Okay, so there's pressure, intimidation, all those adjectives you just mentioned. How does someone go back then and prove that their boss forced them to resign?
So if you've been put in a situation where you've been threatened, you've been directed, you've been told you must resign or else, well, and you choose to do that, make sure there's some record of that. What do I mean by that? Well, you want to be able to establish why you've resigned. So perhaps send an email to your employer saying, you told me today that I have to resign or else. So here's my letter of resignation. Well, that confirms what happened. Or if there's going to be a meeting where you've been threatened, if there's a recording of that meeting, that's helpful as well. But anything in writing is good. So sending an email, a text message, confirming what happened, confirming why you're doing what you're doing is really important. If you simply send a letter saying, I'm resigning and I wish everyone all the best, full stop, it's going to be extremely difficult to show that you resigned because someone threatened you or pushed you or gave you an ultimatum. And in that case, you will not get severance, you will not get EI. So very important, keep things in writing, put it in writing so that later you can get the compensation you're owed.
I want to get one more of these in, Lior. This would be number 5. What happens if someone's in a situation at the workplace where it's terrible, it's a poisoned work environment, as you call it, and they feel they have no other choice but to resign rather than continuing working? How do they handle that?
So if you resign because you feel that there's no choice, for example, as John said here, you're being mistreated, there's a poison work environment. Who wants to work in an environment like that, right? No one, so you resign. Or maybe your company did something to you. They've changed your hours. You used to work days, now they put you on nights. I don't want to work nights, so I'm going to resign. Maybe they reduced your pay. If you resign for that quote-unquote good reason, the law considers that to be a termination. The law considers that to be something called a constructive dismissal. Constructive dismissal happens where your employer puts you in a position where it's reasonable for you to resign. Despite that, that's a termination and you're owed severance. Of course, as I said before, you still need to be able to establish what it is that the employer did. If you could do that, absolutely, that's a constructive dismissal. Before you resign, though, you have to give me a call.
Exactly. Do that. Again, if any of the topics we talk about on the show here any week have you scratching your head, reach out, get more information from Lior or a member of his amazing crew, 1-855-821-5900 and Employment Law Show on radio. As we did in the first segment before the break, we always pull a good phone call from the radio show, hour-long across the country, play them back here. We talk about them because, again, more information, more stuff to be learned. So we'll get to phone call number 2 now, Lior.
Well, I've been laid off since March, April of 2020. I'm only a part-timer, a couple of days a week, but I've been doing that for about 8 years. I haven't heard one thing from the employer of getting back to work. I know that the job I was doing was canceled. That's it. I'm laid off, and I don't know if they'll resume what I was doing.
Mm-hmm.
Probably one of the most common calls that I've been getting over the past, year and a half or so from across Canada. I've been put on a layoff. I haven't heard. I don't know what the status is. What do I do? So let's be very clear, because there is a unified solution here, and that is this. If you've been put on a temporary layoff, regardless of what the company's intentions are, what they plan to do, what they may or may not do, you, the employee, can choose to treat that layoff as a termination. You don't have to wait. You don't have to see what they do. There's no time period that you have to give the company to figure stuff out. If you've been put on a temporary layoff, you can choose today, now, if you want, to treat that as a termination of your employment. Of course, we're talking about non-union employees. In that situation, non-union employees on a temporary layoff, whatever the situation, if you've had enough, you can say, I'm getting my severance. If that's what you want to do, call me. In this particular person, he's been off since 2020. He could have done it then. He can still do it now, treat it as a termination, and get compensated.
Quickly, it was 2020. I think he said April, May-ish. We're past April, May 2021. Does the 2-year limit apply or not in this case? Because he's getting close. Not super close, but he's getting there.
Yeah, if you're going to say that by putting you on a layoff, your employer terminated your employment, you have 2 years from when that layoff began. Now, for some people where they've been put off or on a layoff since the beginning of the pandemic, that 2-year limitation period may be coming up fairly soon. So you don't want to sit on your right, because those can expire.
All right, more to go. Got to take a quick break. We'll do that now, right? 1-855-821-5900 to reach out anytime to Lior and his crew, and help at employmentlawyer.ca. We'll continue. Employment Law Show.
People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. A few minutes to go. John Scholes, Lior Samfiru. Let's get into another phone call. Again, employmentlawyer.ca is the website. You'll find the media section and catch a radio show on a station near you across the country. Phone call number 3, Lior, is coming up right now.
This is for my friend. She has been in company for 21 or 22 years. She is now being offered a position in the same company, which is not unionized. If for any reason she is let go, will her previous employment with the same company count for her severance? She's 57 or 58.
It's a great question.
Excellent question. And let's be clear, you don't lose your seniority because a company gets sold or a company gets restructured, changes its name. You don't lose your seniority. Your seniority carries through in most cases, unless, of course, you sign a document that specifically gives up your seniority. Don't do that, by the way, and sometimes your employer may put that in front of you. But unless you've agreed specifically in writing to give up your seniority, you don't lose it. So for this person, she's been there for 22 years and in her late 50s. If she is let go, even though there may have been a restructuring most recently, those full 22 years will count towards her severance. So she's going to be let go as a 22-year employee. And of course, she's going to be owed a lot more than if she was a new employee. So to see exactly how much she's owed, we've mentioned it before, but let's use it again. pocketemploymentlawyer.ca. We'll use the severance calculator tool that you can find there and use at any time. So let's see how much she's owed after 22 years. So whatever her role is, let's say she's a supervisor. We know she's in her late 50s, 22 years of service. Despite there being a sale or a restructuring, you see at the bottom of the screen that she's owed as much as 24 months paid. 24 months paid. That's 2 years paid. A significant amount. So the lesson here is that unless you agree to give up your seniority carries through the various evolutions of the company, and that means more severance if at some point down the road you're let go.
We'll get to one more shot from terminationquestions.com. Again, a free and anonymous website you can use anytime to ask your questions, have them answered by a member of Lior's team at the firm, terminationquestions.com. This one's from Hannah. Hannah says, when I was fired after 13 years with the company, my friend recommended a lawyer who covered multiple types of law to help get me severance. It's been just over a year now and nothing. The lawyer said they're still working on it, but I'm not so sure. What should I do?
Well, I gotta be careful here with what I say, but I'll be as honest and direct as I can. So first of all, just like with a doctor, if you're going to have back surgery, you're hopefully going to go to a doctor that specializes in those types of surgeries, as opposed to a doctor that also handles dermatology and is a family doctor and also looks at foot care. So you're going to look at a doctor that knows what he or she is doing. Same thing with a lawyer. If you're going to hire an employment lawyer, hire an employment lawyer. If you need someone that does family law, do that. So it's always a bad idea when a lawyer says, I do everything. I do all these things. No one can be good at everything. It's impossible. So there's going to be things there that are missed. Beyond that, a lawyer should always keep their client advised and up to date as to what's happening, what the strategy is, what the timelines are, how are we going to deal with any obstacles put in our way. And if you're not getting those answers, you're not getting that response, that's a problem. You may want to get a second opinion. But I'm always weary when you go to kind of the jack of all trades. It's simply impossible for a lawyer, frankly, for anyone to be good at everything.
Well, and I mean, just as an aside, as opposed to criminal law, I mean, employment law, she says it's been just over a year now. Most employment matters wrap up long before that with you, right?
It would have to be something pretty darn extreme for a matter to be going on for a year or over a year. And it just, not the way employment law cases work. The average span is a few weeks into maybe a couple of months for employment law cases. So if you're being told that your matter is taking over a year and you don't have answers, you have to seek those answers. Something has gone wrong. It shouldn't be the case. And you shouldn't have to just wait for someone else when they're not necessarily doing what's best for you.
Final 30 seconds of the show. Lior, any final thoughts for those with COVID-19 worrying about their employment?
Well, these are obviously difficult time, unprecedented times, but there's some rules to remember. If you lost your job because of COVID-19, vaccinations, because the company is not doing well, in most of those cases, you're still owed compensation. You're still owed severance, okay? It's very important to remember. The other thing to remember is you may have to go back to your job.
Awesome stuff. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.